Facts with Diode.
Hello, good evening to you, and thanks for staying tuned once again. Discussions continue at this time. 9 minutes gone past 5 p.m. Next matter on for discussion: the VAT war between the River State government and the federal government still raging on. Here's an update as far as who is winning who at this time. Maybe I need to ask my guest at the moment who, in every war at different stages, somebody's got to be ahead. But here's a story from the Vanguard newspaper. Rivers drags FG to Supreme Court over VAT revenue. And here's the story. River State government, through its Attorney General, has gone to the Supreme Court praying it set aside its decision of the Court of Appeal that ordered it, River State, to maintain status quo on the collection of value-added tax VAT pending the determination of an appeal launched by the Federal Inland Revenue Service. The state, in its 9 grounds of appeal, is equally praying the Apex Court to order that the substantive appeal by the FIRS and all other processes therein be heard and determined by a new panel of the Court of Appeal. It maintained that a 3-man panel of justices of the Court of Appeal, led by Justice Haruna Samani, had in the ruling they delivered last Friday erred in law when they relied on provisions of Section 6, Sub 6 of the 1999 Constitution and the inherent jurisdiction of the Appellate Court to order all the parties to maintain status quo on the VAT dispute. It argued that the Court of Appeal lacked the powers to restore the parties to the position they were before the judgment of the Federal High Court in Port Harcourt in a suit which was delivered on August 9, 2021. It also argued that the Appellate Court panel failed to take into account the decision of the Supreme Court in Shugaba versus Union Bank 1999 to the effect, quote, that no court has an inherent jurisdiction except in extreme circumstances to set aside the exercise of discretion of another court with regards to order in respect of application for stay of execution. The state argued that the Court of Appeal panel erred in law where they wrongly assumed jurisdiction to entertain an oral application that counsel of the FIRS made for maintenance of status quo by parties in a dispute, despite the fact that condition precedent for the invocation of inherent jurisdiction of the Appellate Court was not fulfilled by FIRS. The River State contended that the Appellate Court, by proceeding to make far-reaching decision based on the oral application of by FIRS, denied it fair hearing. Consequently, it prayed the Apex Court to allow the appeal, set aside the decision of the Court of Appeal on maintenance of status quo, and further dismiss the oral application that was made by the FIRS. And joining me right now in the studio to discuss this matter is the Judiciary playing its role constitutionally in this case. Why has the River State government gone to the Supreme Court? What does it hope to accomplish there? How does this impact the status quo situation? And do we know yet, at least at this time, who is to collect VAT in River State? My guest who's joined me in the studio is Barrister Festus Oguche. Barrister Oguche, good evening. Welcome to Hard Facts.
Yes, thanks for inviting me, Dayo.
As I mentioned earlier on, even though a war in and of itself may not be over, as this one isn't, but at different stages, one might be able to infer who is ahead as far as that war is concerned. Now, there's a war going on right now. In this VAT war between the River State government and the federal government, who is ahead at the moment?
No, you cannot draw conclusions on that yet, because the wheels of justice are still grinding, and the machinery of justice is still in motion. The parties are still in court. The River State government has just filed an appeal at the Supreme Court regarding the order made by the Court of Appeal on the order for stay of execution, which it made the other day. I envisaged it very much. The last time we were here, we spoke about it, and I think there was every pointer to the fact that this matter on the issue of the application for stay of execution will likely end up at the Supreme Court. Professor Zacchaeus Zango is the Attorney General of SAN, he's the Attorney General of River State, and I know that he's not one that will give up on a battle, a particularly legal battle, so just very easily like that.
Now, why not wait? Why isn't the River State government simply waiting? I mean, inevitably, as I think as most people, if not everyone agrees, this matter will go all the way to the Supreme Court. Irrespective of who wins at the appeal court, we very likely are going to see this matter being heard at Supreme Court level, and the Supreme Court will get a final say on the matter. Why not simply just wait till then?
No, it's not done like that. If along the line, while the pendulum of justice is still swinging, any of the parties feel aggrieved by the actions of the court, whichever is the court, has the right to appeal. So it's part of our procedure. It's part of our practice. And I don't think there's anything novel about the Rivers State government going on appeal on it, if particularly the court looking at the grounds of appeal, the grounds which they rely on as the errors of court, and which in totality is telling us that the court lacks the jurisdiction to have made that order. You will not expect the Rivers State government to fold its arms and wait.
Let's talk about those grounds. What are those grounds, and could you explain them in some detail?
Well, I'll be very worried in doing that because the matter is before the Court of Appeal. I will be very careful not to preempt the judgments of the courts because it is already, it's a matter that is pending in court. But it's sub judice. That's exactly what I was trying to reel out. But the main crux of that appeal to the Supreme Court is that the Rivers State government is saying that the Court of Appeal, the justices that sat on the last date that they were in court, shouldn't have given the order staying execution or that the parties maintain status quo in any manner whatsoever. And I think the Rivers State government, which is the appellant now, had gone the extra hog in asking the court to disband that panel and transfer it to another panel. Apparently, that's a very fundamental issue, because if you're saying that this panel has not done this or has not done that in line with the law, in conformity with the law, and you're also saying that they be disbanded or the matter be transferred to another court, you're raising a very fundamental issue.
What's the fundamental issue here? Because it seems to me like they're saying these guys are incompetent.
But in terms of the balance and the objectivity to handle the matter.
So they're not balanced then?
So I'm not saying they're not balanced.
Not you. Is that what might that be what the Rivers State government is saying?
It could be biased.
That they are not objective, they are not balanced.
It could be bias. It could be. But it doesn't necessarily follow that it's bias. It simply means that maybe we are not comfortable with this gentleman, and probably it will all go very well for the dispensation of justice and not to allow justice to be miscarried if you keep them away from this case. Well, I expected that the matter will still return to the Court of Appeal Port Harcourt Division, because that is where it evolved from, and the transfer. Some of us were a little jolted when it was done, but we are reminded that the vacation court, the appeal court vacation court, is in Abuja, and that could be very good grounds for transferring it. And we begin to doubt also whether the urgency that attached to the appeal being transferred is actually real or imagined. But then at the end of the day, I think there's a prospect of having to return it to the Port Harcourt Division where it originally belongs, except maybe somebody would argue that now that Lagos State is coming to be joined, what happens? But then it must come within the base of that Court of Appeal Division where it originated. It originated. Though we've had times like that, I think it's just reminiscent of what happened during the elections when the Election Petition Tribunal was transferred to Abuja, and the good reasons you are giving for that: violence and killings. They were just the state that time was filled with airs of violence and all that. So that could be good reason. But for this one, I think a credible reason have to be given. Credible reasons have to be given for the matter to be retained in Abuja. Now, ordinarily, I think it should be returned back to Port Harcourt.
If the Supreme Court rules in favor of the Rivers State government, as regards this matter, it's taken before the Supreme Court right now, as regards the decision or order of stay of execution delivered by the appeal court panel, if that's reversed by the Supreme Court once again, what does that mean for does that have any immediate impact or effect on who collects VAT?
Even the order made as it is, even prior to the appeal, doesn't have any impact at all on who collects VAT, because it has nothing to do with it whatsoever. We are trying to look at where the order is targeted and for what reason, and it's very difficult to maneuver through the state-related issues and facts to actually locate where that order is targeted. So I think it's just to keep the record straight.
Okay,
that, the court could not.
So there is. So maybe, pardon me. Maybe there is some confusion. I mean, the interpretations might differ, or companies, businesses might have some concerns as to how they are to proceed, considering that appeal court order. If the Supreme Court sets that aside, that means that element of quote-unquote confusion is completely eliminated, completely removed, no longer part of the equation. Who then is the coast clear for to collect tax or to collect VAT, pardon me?
As it is, and this is what I said the other day, the coast is always clear for the River State government to collect VAT as it is, because and that also happens to be one of the grounds of the appeal. There's no order of the Court of Appeal at this stage that can nullify or set aside or make it impossible for the law of the River State to be operated. The court has a duty to respect the law of the River State. So as it is, whether the order is subsisting or the Court of Appeal makes a contrary order or reinstates that order or continues with that order, it doesn't make any difference at all. Going by the fact that the law itself was not part of the subject matter of the decision of the Federal High Court, and it was promulgated immediately after the decision of that court, and so it doesn't have any implications whatsoever. For you to challenge the law, you have to go to a different court with a separate and independent action, distinct on its own, to challenge it, because it is an existing law by virtue of the Constitution, and it is a law that must be enforced at all times. So the law stands on its own, totally separate and different from all these areas of controversy that are beginning to brew.
Also, now, the River State government maintains that a 3-man panel of justices of the Court of Appeal had, in the ruling they delivered last Friday, erred in law when they relied on the provisions of Section 6, subsection 6 of the 1999 Constitution. What exactly is that section, and what does the River State government mean that they erred?
Yes, it empowers the courts to determine all controversies, all issues, to determine the civil rights and obligations of citizens against the government and government against government and everything. I think that's a law that has to do with judicial power, as different from jurisdiction. Judicial power is the power of courts to adjudicate, to give decisions that are binding. Jurisdiction is the circumspection of the competence of that court within the circumference of its area of competence. So that's the difference. But that provision gives the court the power from contained in the law. But in doing that, it must be in connection with the provision, that particular provision that empowers it. What the ground of appeal is saying is that the Court of Appeal cannot make a grant for stay of execution relying on its inherent powers under Section 6, subsection 6, subsection B. That for you to make that stay, you must rely on a law, a particular provision of the law. Inherent powers does not allow you to go on a how do I put it? To go on a frolic on your own, to look for anything to do and all that. The courts, they have their own limitations judicially and legally, and these limitations are defined by the areas of the circumscription of their powers and extent. And once you exceed it, it becomes a nullity. And that's why the other day I alluded to the fact that probably that particular order made by the court was made out of outside jurisdiction. The court's jurisdiction could it have been properly invoked? And these are just essentially the grounds of appeal. For instance, that they cannot restore the parties to the position they were, before the judgment of the Federal High Court. That's one other ground.
We'll have to go for a commercial break right now. We'll return in a moment. The conversation will continue. Do please stay with us.
Information is a two-way thing. Nigeria Info, it's your turn. Let's talk.
Headline News, Nigeria Info on
92.3.
Headline News.
Hello, welcome. Thanks for staying tuned. Here are the headlines. Former President Goodluck Jonathan not defecting to APC. Buhari swears in 3 INEC national commissioners as fake commenters. And FG promises to restore Twitter. River State government demolishes shanties in Nkpogu, Port Harcourt. A wife of man declared wanted by River State government says is still missing 48 hours after. Edo State government begins enforcing barring of all unvaccinated civil servants from work. A Unibank VC orders closure of varsity as students continue protest. On a foreign scene, Zimbabwe bars unvaccinated civil servants from work. In entertainment, Ed Sheeran says award show's room is full with resentment. In business, Nigeria's inflation rate drops further to 17.01% in August. Those are the headlines. Details at 6 p.m. Contact our newsroom on 0818 90017. For more stories, visit www.nigeriainfo.fm. Thanks for listening. I'm Adedayo Elusakin. Good evening. Our freedom depends on our proactive responsibilities.
Let's talk, act, and be about development.
With one voice, our potential is realized. This is your #1 news, talk, and sports radio station. 92.3 Nigeria Info. I am listening.
And now, hard facts.
Hard facts with Dion.
Welcome back. Still had facts 90.3 Nigeria Info here in Port Harcourt. I'm Dio. We got 27 minutes to go before 6 p.m. and we're still discussing the VAT war ongoing between the Rivers State government and the federal government. Rivers drags FG to Supreme Court over VAT revenue. That's from the Vanguard newspaper. My guest still with me in the studio, Barrister Festus Oguche. So you're welcome once again.
Thank you very much.
Let's talk about some of the grounds on which the River State government is challenging the decision of the appeal court. The River State government also argued the appellate court's panel failed to look into account a decision of the Supreme Court in Sugar Bank versus Union Bank 1999 to the effect, quote, that no court has an inherent jurisdiction except in extreme cases or circumstances to set aside the exercise of discretion of another court with regards to order made in respective application for stay of execution. What does this mean?
It means that if a court gives a judgment or gives a decision by virtue of its exercise of discretion, no court can set it aside. Relying on the inherent powers of that court. That first of all, the court can only set it aside or any aspect of that decision or any aspect of that ruling or judgment by virtue of the law, and not to look for inherent powers from nowhere that are not defined. Inherent powers are amorphous. It's there, just those ingredients that attach to a court's power and competence to take decisions without recourse to the law. If the law doesn't make provision for a particular thing, the court can exercise it by virtue of its inherent powers. So what it's saying in that Sugar Bank case is that if a decision has been made by a court exercising its discretion, whether on this way or the other way, another court or a court of appeal cannot set it aside or nullify that decision upon reliance on its inherent powers. It must rely on a provision of the law.
Also, the state argued that the Court of Appeal panel erred in law when they wrongly assumed jurisdiction to entertain an oral application that counsel of the FIRS made for maintenance of status quo by parties in a dispute, despite the fact that condition precedent for the invocation of inherent jurisdiction of the appellate court was not fulfilled by FIRS.
The condition precedent it is talking about there has to do with jurisdiction of the court. You know, there are the ingredients that make the court have the power to make any order or to sit in adjudication on a particular matter. If the condition precedent is not there, and maybe I think that particular provision is relying essentially on the fact that the respondents had not responded. They had not reacted to the motion for stay of execution, which was filed by the Federal Inland Revenue Service, and their time is still running. If you go down that particular ground, you see that they talked about violation of fundamental rights, you know, of the respondents, because they needed to be heard. At least they have to tell their own side of the story. Then the court will bring them together, bring all these facts together, all these arguments together to take a decision. But it just relied on the oral application of the Federal Inland Revenue Service Council to make that order. So the conditions precedent to the court assuming jurisdiction to hear it in the first place are not there. And they're also alleging violation of fundamental rights, you know, in that particular ground, which they say occasion miscarriage of justice. And that's a very strong ground because it touches on a very fundamental area of judicial proceedings. And that is the two pillars of adjudication, that you must hear the other side. You know, fair hearing. You must give them the opportunity to be heard before you do anything that will affect them.
I want to give you thoughts or contributions right now, maybe a couple. Call the numbers. The lines are open, 0817 923 0002 or 0003 or 0007. Via Facebook, we're live there on facebook.com/Nigerian for PH. And WhatsApp is on 0809 030 6416. Let's see, via WhatsApp. Good evening, and guest. Federal government should allow each state to collect their VAT, although it's not accounted for either by federal or state. It will end like NGDC money and projects. Fake people, fake government, fake representatives, and gullible followers. It's a pity we find ourselves here. That's from Douglas. Hello, Dan Barrister. If the River State law right on the court's decision that has now been stayed, how then can we say such a law still stands? Does this not seem similar to a man who's been offered a job still going ahead to take the offer when his degree which qualifies him for the job is suspended? Mark Paul, I think the simple answer to your question is, if nobody bothers to check the validity of that degree, then what you're talking about does not matter, because the River State law has not been contested in court. Am I right?
It hasn't been contested, and you don't connect it to the decision of the Federal High Court. It stands on its own, you know. And for you to contest it, you have to file a fresh process to have it set aside.
And once again, the Federal High Court decision was simply a declarative decision. It did not pronounce any order.
Nothing like that. So you cannot say it is subsequent to that judgment. It's on its own. It's separate. It's distinct. That law was made pursuant to the powers of the House of Assembly to make it. If at the end of the day this matter is resolved in favor of FIRS, it doesn't even nullify that law until you go to court and take steps to repeal it, to nullify it in any way you deem fit, because it's not even part of the subject matter of adjudication before the Court of Appeal. The court are only seized with the circumstances and issues and cases before it. It cannot go. It's not an all people's dispute settling tribunal.
Let's take a call down, please. Okay, he's gone. Patrick from Rumasi, welcome. Go ahead.
Yeah, Daniel, good evening.
Hi, go ahead.
Good evening to the lawyer. I think the man there has, my own view, has done justice to all the questions you've asked. River State governments have done the right thing, in my view, because this is already a law. An appeal is now made to undo a law. I don't think I've not heard where that is done. So, federal government or FIROS or whatever it calls it, should wait till there is an appeal. That order does not stand. So I am 100% support of River State government and His Excellency, our Toknadu governor, to proceed and see the logical conclusion to this matter. Meanwhile, VAT should be paid to River State government as we speak, because moreover, that is the status quo in my own view. Thank you.
Contrary to Patrick's opinion that an appeal cannot cannot, I've forgotten the word he used right now, sort of meaning repeal a law. I have a feeling that's not entirely correct. If the law was being contested, an appeal can repeal a law.
Yes, even if it is not contested, but to look at the law and it is inconsistent with the provisions of the Constitution, the Constitution gives the courts the power to repeal such laws, either directly or indirectly. Those are there. But then it has to come by way of an application. It has to be the subject matter of that appeal. It has to be before the court. If a law is prima facie inconsistent or contrary to the provisions of the Constitution, it cannot stand. What the court will do is to set it aside. So when we get to that stage and they deem it necessary that the laws of Rivers State regarding that cannot stand in the face of the Constitution, where the courts can set it aside in spite of the fact that it is not part of the subject matter of this suit. But we have not gotten there. That's the crux of the matter. But for you to do anything contrary to the law for now, it becomes a nullity and it becomes even criminal. Because as at this current stage, there's nothing, like you said, which I agree with you wholeheartedly, there's nothing challenging the law for now.
Via Facebook, Austin Jumbo goes, I'm not still at the courage of the Rivers State Governor to right move in the right direction. Kudos to the barrister in the studio who's done a great job. A quick call from Doris. Doris, you have a minute. Go ahead.
Hello, I want to say that I am really happy with what the Rivers State government is doing, the way they are going about pursuing their case. But the teachers of the Montana secondary schools owned by Rivers State institutions went to court.
Doris, I apologize, but I cannot entertain that line of conversation right now. But great to hear from you, though. Some other time we'll discuss the teachers' matter. We can delve into that. But we have to wrap it up right now. We've got a commercial break coming up. Thanks for being a part of it. And thanks extremely to my guest, Barrister Festus Oguche, for making our time once again to break down the nitty-gritty of the ongoing VAT war. Many thanks for your time.
Thank you very much. And we look forward that there will be serious legal fireworks at both the Court of Appeal and the Supreme Court. And I think we have to keep our minds open. At the end of the day, it will develop our law. It will give us better license for constitutionalism and democracy.
Commercial break comes up right now. Major news top of the hour at 6 p.m. If you've missed out on contributing to any matter on the show today, I'll take your thoughts after the major news at 6 on the open season segment at about 7. Do please stay with us.